right, guys, thanks for joining me. Can you guys hear me? All right, good. I'm gonna go ahead and put the earpiece in just because we're on the train. It's a little bit loud around, so please share if you guys can. I kind of want to go over some of the stuff we talked about this morning. I know that it was really glitchy on TikTok, so let's see if we can not have it glitchy this time around. But I wanted to go over the things we talked about this morning. We had a really low turnout. I mean, we averaged like 12 concurrent users, which is worlds worse than it has been up until this point. So thank you for joining, Facebook. Thank you for joining. We're going to just talk about some of the things we went over this morning once again. So we'll start in just 1 second here, guys. Just 1 second. I'm going to put out a video here before I get off this train. We're heading down to Southern California right now, and we're going to be there for one night. I've got a couple things that we need to do tomorrow down in Southern California, and then we're probably going to be heading back toward the east. And Texas area, New Mexico. I'm going to go serve the AG and the Supreme Court of New Mexico because we hadn't served them yet. So we need to get them incorporated. That's going to bring us up to 34 states that have been served, both AG and Supreme Court. So we're going to head that way, make that happen. We have already served Arizona, so we're just doing some state pickups right now, and we'll probably make our way over to Tennessee, Arkansas, and Kentucky. Those three haven't been served either, as well as also West Virginia. I can't say exactly when that's going to be, but right now we need to get the rest of the states incorporated as well before we get to that point. We are going to be heading toward Ohio. I was thinking about doing it before we headed back west, but it just didn't work out, and so we'll be up in Ohio before long. I know Cleveland. We have intent of doing some stuff in Cleveland area, but Ohio has been served. We have served both the Supreme Court as well as also the Attorney General of the state of Ohio. In fact, the Ohio Attorney General was a really funny service. You guys, it's available on Rumble. It's available on Facebook. I believe it's here on TikTok as well. When I served the Assistant Attorney General, lots of times they see me and they just assume that I must be a U.S. attorney. I mean, the way I dress and everything. So when I went in, I said I had evidence that is ongoing litigation, and I needed to deliver it to an assistant attorney general, and they allowed me upstairs. That was one of the very few places that they actually gave me free reign into the building, and so they let me go upstairs. And then one of the assistant AGs met me there, and he's like, "Well, what evidence do you got?" And I gave it to him, and he read it and absolutely threw a fit. I mean, the guy threw it down the hallway, and you see, I mean, the guy just threw it down the hallway and went stomping off saying, "I don't accept service, I don't accept service." And well, unfortunately, it's sitting in your hand. You don't get to choose whether or not you accept service. Service was provided. And so I got out of there pretty quick and got on our way. Chicago, yeah, we're gonna be in Chicago as well. Chicago, I need to reach out to the torture center there and do some work with them. I've talked to them in the past, and they do a lot with police brutality issues. Illinois is well known, Chicago is well known for just some horrible injustices that need to get corrected and need to be brought to light. So yeah, I'm going to be back up in Chicago here before long. That's kind of a central point for the train anyway, so we'll be there very soon. Yeah, I thought that the Ohio service was a good video. I mean, it just goes to show how much these guys actually respect the will of the people. And that's sad, because this is a crime that's being committed by the Attorney General's agents, the prosecutors within the state of Ohio, and he reads it and he throws a fit. I mean, literally throws it down the hallway and stomps off, screaming like a little child. I mean, that's how much they respect the people of the United States and the laws that we put into place and the crimes that they are committing. I don't accept service. Well, once again, I mean, we don't really care whether you accept service. You need to get this addressed, because you cannot commit crimes and then say, well, I don't accept service. No. So, when it comes to serving people, when it comes to service, all you have to do is put it into their hands. Once it's in their hands, service is provided, and they can't deny it. They can't refuse it. It doesn't have to be in any certain form or whatever. So, serving the attorney generals, when I did the first tour around the country, it was kind of a pain in the butt to serve them, because they lock the doors. They don't give you access. There were times, like in the state of God, I want to say Indiana, maybe, that I couldn't get in. They wouldn't allow me to get in. They wouldn't allow me access, and I actually waited in the parking garage in the elevator for someone with a badge to come along so that I could serve them. And so I'm sitting in the parking garage elevator, and I wait for someone to come along. And I'm like, oh, are you an attorney general? Well, yes, I am. Awesome. Here you go. So yeah, I mean, it was tough to serve the AGs, but not so much the Supreme Courts. Supreme Courts were always open. There's always a clerk of court available, and as long as it's working hours, the clerk of court is the agent of the Supreme Court. That's who you would serve if you were going to serve the Supreme Court. So there's your agent, and serving the Supreme Courts were a lot easier than serving the attorney generals. They were a pain in the butt, and they didn't like it very much. So. Yeah, Boston, we will be up in Boston, absolutely. We have served Massachusetts, both the Attorney General as well as the Supreme Court. Both those videos are available on TikTok, on Rumble, on Facebook. They're readily available. State of Massachusetts is going to have to respond to these allegations as well. And so, yeah, we will be up in Boston. We have to come to New Hampshire because the consolidation point for these affidavits is in New Hampshire. It's Joseph Everett. So anybody in that area that's going to be getting the affidavits, they're going to be sending it to Joseph there in New Hampshire. So we're going to have to come up there anyway. But yeah, I mean, Boston is a big target point. They charge by way of information, and there's no denying it. So they're going to have to respond to these allegations as well. We'll be up your way. I don't have a date yet. Right now we're still having funding issues, but I'm going to a place right now. We're going to Southern California first. We got some meetings tomorrow that hopefully we'll get some good response back as well from the state of California. You guys got to understand, like, this issue of the absence of the indictment grand jury, it originates from the state of California. It was the state of California that created all of these problems that all these states are doing. It was a case called Hurtado versus California from 1887. And so, the state of California is ultimately responsible for leading the whole entire country astray right now. And so, they kind of need to accept responsibility for the fact that, states do not have the authority to substitute their own alternative legislation for the guarantees of the Constitution and then direct their agents to act in a manner contrary to what the Constitution so demands, because these agents are bound and accountable by oath or affirmation to what the Constitution dictates, and those are their obligations. And when you fail to fulfill an obligation, that is also known as a crime. So, we need to make sure that they understand that these are crimes that are being committed, that an agent of government has an obligation by oath or affirmation when they enter into their office that they will do what the Constitution of the United States says, particularly judges and prosecutors. And, those are obligations, right? Obligations. And so an obligation can be seen from two different perspectives. From the one bound, the obligation is a duty. From the one entitled, the obligation is a right. So when you have an obligation, right, then that means that you have a duty to act. And of course, when you breach a duty to act or fail to do it willfully or negligently, that is a crime. That's the crime that we're dealing with. Because remember, any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any rights secured by the Constitution commits the crime of deprivation of rights under color of law. So, no public official can fail to fulfill the obligations that they have. Someone asked a question earlier about jurisdiction, because I just posted a jurisdiction video. You guys are able to see it. And someone just posted a video about jurisdiction or a question about jurisdiction. And they said, well, if there's an obligation for them to hear it, for the Supreme Court of the United States to hear a case as the court of original jurisdiction, then does that mean that they can use their discretion to not hear it? And the answer is no, you guys. You cannot abuse your discretionary authority to breach a constitutional obligation, because that would be abuse of discretion, right? And that's upheld in a lot of different places, right? That's upheld in statute. That's upheld it's in a lot of different places. Okay, so abuse of discretion. If you want to find out what abuse of discretion is, which is what happens when you abuse your discretionary authority to disregard an obligation or breach a constitutional obligation, then you would go to the Circuit Court Handbook, right? The Circuit Court Handbook describes the two-part test that is used to determine abuse of discretion. Now, it says that the first part of the test is, did the judge render a decision that he apply an incorrect test? And, you know, in the case of a child, for instance. So there's 4 levels of judicial test, 4 levels. The highest is known as strict scrutiny, which requires the compelling state interest test. And that means that basically, yes, you have to go out and prove that there's nothing else that you could do but deprive this person of this right. Every single fundamental right requires strict scrutiny, compelling state interest test, the highest judicial test. Now, the reason why they have to prove to someone else that there's nothing else they can do is because when it comes to a federal constitutional right, a state cannot breach or take away a federal constitutional right, because if they do, that's a federal issue. And we know every single day that they tell us, oh, that's a state issue, go back and argue with the state, right? That's a state issue. And so, you know, there's a separation of powers. There's state issues, there's federal issues, but the federal constitution resides outside of the state's limited or statutory governing limits. So when a state chooses to exceed the power authority statutorily conferred upon it by the Constitution and breach a federal right, that's not a state issue, that's a federal issue. So at the end of the day, they have to, they have to use the highest judicial test. Now, the lowest judicial test is what's called the discretionary test. A judge can never, ever use discretion in order to abridge a constitutional right, because that's a constitutional obligation. It's a duty that they have to ensure, protect, and preserve it. So constitutional law 171 says state courts and federal courts are equally obligated to guard and enforce every single right secured by the Constitution. So if the Constitution says that you have the right to have an intimate association with your child without governmental interference, that's the obligation of the judge. He has an obligation to preserve and protect that right. And if he doesn't, then guess what? He has abused his discretionary authority by applying the incorrect judicial test. And according to the Circuit Court Handbook, any time that the judge abuses or applies the incorrect test, that would be an abuse of discretion. Now, the second part of the test is any erroneous view of the law is an automatic abuse of discretion. Now, an erroneous view of the law, for instance, would be that in the judge's legal contemplation, that the inferior state statute that permits him to abridge a constitutional violation is in legal contemplation superior to the guarantees and protections of the United States Constitution. That would be an obvious erroneous view of the law. The highest form of law is the supreme law of the land, the Constitution of the United States. Therefore, when you rely upon an inferior law that permits you to abridge a guarantee of the Constitution of the United States, that would be an erroneous view of the law. Therefore, an automatic abuse of discretion has occurred. And according to Blackstone, anytime that there's an abuse of discretion, there's 3 crimes that automatically occur. Automatically. One is extortion, because they are compelling a result through illegal means, right? So they're abusing their discretion in order to take away a right guaranteed by the Constitution. So they're compelling a result through illegal means. The second is perjury, because they are failing to fulfill the promise that they made, right, upon entering into their office by oath or affirmation. They're failing to fulfill the promise, and you have already implicitly invited punishment in the form of perjury should you fail to fulfill that promise. So then the third crime is oppression. Oppression is when you apply the law unequally amongst different members of society. So when the judge makes a decision that he's going to permit this person to continue to have a relationship without governmental interference of their children, but not this person, that would be a person in a position of authority applying the law unequally amongst our society, which is the crime of oppression. So those 3 crimes are automatic. They're per se as a result of any abuse of discretion by any public official vested in law. All right. So again, this morning I had a conversation about a number of different things. And one of those is risk, all right, risk. So, you know, a lot of people look at what I'm doing and they're like, you know what, this is never going to happen, right? They'll never let this happen, right? You might be right, but you'll know. And you know what? I've heard that from a lot. I've talked to tens of thousands of attorneys across the country. I've tried to get people to support this, especially, attorneys and so on. But at the end of the day, every single one of them have said, well, you're right, but you're not going to get our help because we don't bite the hand that feeds us, right? They say, yeah, this is right, and you're probably going to win, but you're not going to get our help, and that's what they typically want as a response in this is that these attorneys, they're in the business of, and so this is what they do, right? This is their industry. They don't want this industry to go away, and I understand. I mean, you're making a shitload of money at the expense of citizenry. You're making a ton of money through your illegal acts, and of course, there's a maximum law that no one can profit off of their illegal acts, and yet look at these attorneys, look at these judges. They are profiting off of their illegal acts, and then they throw the paperwork down the hallway and say, I don't accept service when we call them out on their bullshit. So, but when you look at risk, I mean, a lot of people say this is probably never going to happen. And this is a big, this is the biggest civil rights case in American history. This is probably never going to happen. And this in the end is going to make Brown versus Board of Education look like small claims court. This is a massive, massive case, you guys. It's a massive case. But the thing is that in order for us to win, we do have to get them to admit that for 243 years they've been doing things improperly because they've been relying upon not Constitution, not common law, not the will of the people, but they've been relying upon what's called judge-made rulings, right? And judges don't make law. So when a judge makes a ruling, right, and then calls it law, case law, and places it at the foundation, removing that which is the common law, the will of the people, the Constitution of the United States, that would be an unconstitutional act because judges don't have the authority to create law. So, but that's where we're at. I mean, we have judge-made rulings that is the foundation, and we go to judge-made rulings to determine whether or not a constitutional violation has occurred. I mean, if you were to bring up a complaint to a court and say that my rights have been violated, where does that judge go to determine whether or not your rights have been violated? Does he go to the object of which his fidelity is bound, the Constitution of the United States, to determine whether or not you have that right? Or does he go to case law? Does he go to the flawed decision of the man that comes before him or the flawed decision of the man that came before him? They go to case law. And case law is the exact opposite of Constitution, right? Constitutionalism is majority, right? We create the law, and it requires the suffrage of the people to alter, amend, or destroy it in accordance with the Special Amending Procedure of Article 5. So it takes an act of the people to alter, amend, or destroy the Constitution of the United States. Now that's the will of the people. Majority makes that decision. So therefore, the opposite of constitutionalism then would be one single judge imposing his will upon the rest of the nation, right? That would be the opposite. So they don't go to the object of which their fidelity is bound, the object that they swore by oath or affirmation that they would support and defend and be obligated thereby anything in the Constitution or laws of any state to the contrary notwithstanding. Instead, they go to, again, the flawed decision of the man that came before him or the flawed decision of the man that came before him. So what we're doing here is we're seeking to destroy a massive number of unconstitutional laws because judges don't create law. The people create the law in accordance with Clause 1, Article 1 of the United States Constitution. All legislative power is vested in Congress of the United States, consisting of a Senate and House of Representatives. So the people create the law, the legislative branch creates the law, the judicial branch does not. And just like the Supreme Court said in Norton versus Shelby County, that any unconstitutional law creates no office, provides no protection, it is inoperable, has never even existed, and it is not inoperable from the moment that it's deemed such, but rather from the moment that it was created as though it was never even created because it was always unconstitutional. So if judges don't have the authority to create legislation because all legislative power is vested in the legislative branch, therefore law is what's legislation. Legislation is law. That's all it is. So when a judge creates a ruling and calls it law and then directs everyone to follow what is not law because judges can't create law as a separation of powers, then what? And then directs everyone to follow what is not law because judges can't create law as a separation of powers, then what they created is unconstitutional. And once again, when you go to Norton versus Shelby County, the way you deal with the unconstitutionality of a law is that you remove it. You remove it from the moment that it was created. So all of these judge-made rulings that the states have relied upon to create their own laws, right, that are contrary to the Constitution of the United States because they're relying upon a judge-made ruling to do it, Well, unfortunately for them, those state statutes are also going to be unconstitutional because they relied upon something that was unconstitutional to create them. And that means that every single contract that was established relying upon that state statute, once it's removed, including all these convictions, right, are all pertaining to that law. Once the law is removed, all the contracts must be removed, right? So if we go to the judicial branch, we say, all these things that you guys did was illegal and unconstitutional. We're going to remove all this bullshit that judges put into place, that slave owners put into place, that has built their slavery institution, right? We're going to remove that because they never had the authority to create law, because the people created them, and people did not create the Hurtado versus California, Barron versus Baltimore, any one of these other things. When the judge creates something that is not law and directs all the people to follow something that is not law, then the states rely upon that and say, okay, well, we're going to create this. So let me give you another example here, a better example. Just 1 second, guys. I had someone call in trying to break what we're doing here, so I need to resume this here. Just 1 second, guys. 1 second. Sorry, Facebook. We had someone come in and call here, so I need to resume this here. Just 1 second, guys. 1 second. Sorry, Facebook. We had someone come in and call. That seems to happen a lot. People like to make these phone calls. So let me just lay this out for you. So the Supreme Court of the United States, they came out in 1887 in a case called Hurtado versus California, and they said, you know what? California, you don't have to have an indictment by grand jury. You can charge by way of information. You can do that. That's fine. You don't have to follow the procedures and process of the Constitution for the United States of America. As of that moment, the highest court in the land chose to use a ruling that they called law, case law, that then amended the Constitution of the United States of America in a manner other than what is prescribed. Because we can go to the special amending procedure of Article 5 to determine how to change it, and the way you change it is not through a judicial ruling. If judicial branch, if you don't want to have an indictment by a grand jury because you think that it's too laborious to do that, then that's fine. Present your argument to the people of the United States, get them to agree to it, alter the Constitution in a lawful manner, and if you don't, then that ruling is unconstitutional because the judicial branch has no authority to alter, amend, or destroy the Constitution for the United States of America. So in 1887, the highest court in the land directed all of the courts across the country, all the state courts, that they don't have to do what the Constitution of the United States of America clearly states that they must do. They must have an indictment by a grand jury before arresting someone and holding them over for a capital or an impus crime. And so now these states said, oh, well, that's a good deal. We don't have to have an indictment because that's a pain in the butt. We want to be able to arbitrarily, capriciously arrest anybody for any reason we want. So then they created a statute, such as the state of Washington, where the state of Washington, Article 1, Section 26 says, no grand jury shall be drawn or summoned in any county. So if the Fifth Amendment to the United States Constitution, ratified by the people on December 15, 1791, in all intents and purposes, in accordance with the special amending procedure and the proper way in which you amend the Constitution, says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, that's clear. You must have an indictment by a grand jury before arresting someone and holding them over for a capital or infamous crime. So, state, when you chose to enact a statute relying upon a judge-made ruling that they called law, which we've just said that judges don't create law, they cannot legislate from the bench, that's a separation of powers issue, and according to Norton versus Shelby County, that any unconstitutional law is unconstitutional from the moment it's created, which means that in 1887, when the Supreme Court directed all the states that they don't have to do what the Constitution of the United States requires for them to do, and the states relied upon that inferior ruling that they called law unconstitutionally in order to create their statutes, well, that statute is unconstitutional because it was created based upon something that we can now deem unconstitutional, right? So we nullify and void the judge-made rulings that was bullshit, right? And when we do, then the state statutes, they have to follow as well because they're progeny to it, which means that all these convictions that are relying upon these inferior state statutes that say that they can charge by information, not by indictment, must also come out. Every single one of them. And it's not from the moment that we win this argument, because according to the Supreme Court in Norton versus Shelby County, that an unconstitutional law is always unconstitutional. Not from the moment that it's deemed such, but from the moment it's created. So we have an opportunity right now to go back to 1887 and say, you know what? We're going to take all this shit out. We're going to take all this away. None of this is valid. None of this is real because it's all relying upon something that was unconstitutional to establish it. This is a big, big, big fucking deal. Big deal. But that's why I say that, that when we look at the risk here, right? When we look at the risk, yeah, this is a big deal. And it's a difficult thing to do. That's why I've been at it for 9 years. That's why, every single day, I sit here and I'm like, you know what? This could be the day that we win because we're that close to winning. We're right across the board. Every single thing is in our favor. It doesn't matter whether it's the Constitution, whether it's United States Code, whether it's the very words of our founders and forefathers in the Federalist Papers, Circular Number 10 or Circular Number 78, whether it's the Judicial Code, Title 28, 455. Every single thing is in our favor, including Supreme Court precedent in Martin versus Hunter's Lessee, Cohen's versus Virginia, McCulloch versus Maryland, Chisholm versus Georgia. Every single thing is in our favor except for a bunch of judge-made rulings, which I can show that they're not valid. They're not valid. They aren't true, right? Because the judges don't have authority to be able to create law. Judges are tethered to positive law, which means that their rulings must be consistent with positive law. They don't have the authority to be able to breach the will of the people, all right? So, yes, this is a very, very big deal. But when you look at risk, right? When you look at risk, because a lot of people are trying to figure out, well, how do I overcome this injustice that's in my life right now? They're coming after me, wanting to take me to trial, or they've already imprisoned me and and they're trying to figure out some way to overcome this injustice, and they deserve to have justice. I get that. But when you go to an attorney and you say to an attorney, I'd like you to deal with this conviction, right? I'd like you to deal with this conviction that was put into place. That attorney is trained to put you into prison. He's not trained to get you out because he has a degree in locking you up and making you a criminal because he deals with ordinances, statutes, judge-made rulings. Those are the things that they're trained on. So they rely upon administrative law. Now, when you understand what administrative law is, what it is that there's 3 different branches of government, right? The first branch is the legislative branch. They are there to create all legislation. That's why Article 1, Clause 1 says all legislative power is vested in a Congress of the United States. So all power to create law is vested in the people, the legislative branch. The second branch is the executive branch. Now they're there to enforce the law. They create what's known as orders, right? Executive orders. But orders only affect those that are being ordered, right? So executive orders don't affect the people because the president can't order the people because he's a servant to the people. So executive orders only affect those within the executive branch, right? They don't affect the people because they're not law. And that's what came out in the Chevron ruling recently in last June is that the Supreme Court said to the executive branch, no, you don't get to create law. You don't get to amend it based upon your policy and your ambiguity. You don't get to do that, executive branch. And that was the correct ruling because, up until that point, we were seeing the executive branch alter, amend, or destroying the law based upon what they call their ambiguity by writing orders, policy, and then directing everybody to follow policy, right? And policy is not law because the executive branch has no authority to create law. So that was the first part. We had to get the executive branch held accountable for what they were doing, but now we got to go to the judicial branch because the judicial branch has to now be accountable for their crimes in the same way that they pointed at the executive branch and said, no, executive branch, you don't get to create law. We need to now have the judicial branch say, oh, bullshit, you don't get to create law either, judicial branch, because the judicial branch is what's known as the administrative branch. They are there to administer the laws. So when the administrative branch creates a ruling, because that's what the administrative branch does, just like the executive branch creates orders, the administrative branch creates rulings. But rulings only affect those that are being ruled, right? Those which are judges. So they direct all the judges to do what they say because all the judges are ruled over by the Supreme Court. The Supreme Court is not ruling over us because they're a servant to us. So rulings don't affect the people once again because only a law affects the people. But when the judicial branch creates rulings and then calls it law, that is what's known as administrative law. Administrative law. So when you have administrative law being the foundation, right, that all the courts are relying upon to determine, the outcome of a dispute, then they're relying upon something that is not valid. And that's why attorneys are what's known as administrative officers of the court. If you were to read the Corpus Secundum, Volume 2, which is the handbook for attorneys, it says that an attorney is an administrative officer of the court, which means that they are there to administer and work for the administrative branch. That's why they rely upon judge-made rulings, because that's what they're trained to do. So when you go to an attorney and you say, okay, I want to get relief for this injustice that's occurred, all these constitutional violations that happened to me, right? And now I'm imprisoned and enslaved as a result of it. They don't have the expertise or the knowledge base to be able to do that because they are relying upon judge-made rulings. So what they do is they look at the end. They tell you, you need to go and appeal this judgment, right? You need to appeal it. But if the judgment is void because the court never had authority to even be able to oversee the dispute, because the Constitution says that in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction, then at the end of the day, then that judgment is void because the court didn't have authority to be able to even call you into that courtroom. You see, that's the jurisdictional video that I just put out, is that what you got to understand is that jurisdiction was created by the Constitution, right? It's the Constitution that created jurisdiction. And then jurisdiction is what creates the courts, right? So jurisdiction came before the court. Therefore, it's not the court that grants jurisdiction. It is the law. It's the statute. So it's the case that grants jurisdiction, not the court. So when you go to, for instance, when you want to appeal something, right? You want to appeal your judgment, and you try to go into federal court, and they say, "Oh, you got to go back and you got to exhaust state remedies. You got to get a decision from the highest court in the state before you can come into the federal court." That's not true, because it's the case that determines jurisdiction, not the court that determines jurisdiction. Because Article 3 says, "In all cases in which a state shall be party, the Supreme Court shall have original jurisdiction." So it's the case, not the court, that grants jurisdiction. And if the case is State of Washington versus Tom, then that is clearly a state named a party. Therefore, that is what creates the jurisdiction for the Supreme Court of the United States, because Article 3 says, "In all cases in which a state shall be party, the Supreme Court shall have original jurisdiction." So going back to what the question was from the guy earlier, he said, well, does the court have the ability to be able to dismiss the case, even though they have a constitutional obligation? The answer is no, absolutely not. Because you can never, ever, ever abuse your discretion, right, to breach a constitutional obligation. So if the Constitution created the obligation for the United States Supreme Court to oversee any case in which a state is a party, that's the obligation. Therefore, if the Supreme Court says, oh, we're going to use our discretion, because they believe that they're a court of discretion, if they use their discretion to dismiss the case that we're bringing forward, because I'm there to invoke Article 3, that's what I'm doing. I'm not asking them to hear the case. I'm telling them, you have an obligation to do it. So you can either, one, fulfill the obligation that you have, or two, you can tell 330 million people that you're not going to follow the Constitution of the United States, and good luck getting home if that's what you choose to do, sirs, because I think that we live in a world that's very, very patriotic now today, and I don't think that there's very many people that are going to put up with those justices saying that the Constitution of the United States is not going to be adhered to. Not only that, but they would also destroy their institution, because if they make that statement, they say the Constitution doesn't apply, we're not going to follow it, then that means that the state's courts are more powerful than them, which means that they no longer have power. They no longer have an institution. There is no longer a Supreme Court, because the state courts are more powerful than the highest court in the land. So it wouldn't be wise for them to make this decision. So, yeah, I mean, they cannot use discretion. But the other thing is that they can't delegate it. Because if they were to delegate the duty or the obligation, right? If the Supreme Court were to say, yeah, well, we're gonna have the district courts be the ones to oversee the case, not us, then that would be altering, amending, or destroying the Constitution in a manner other than what's prescribed. The Supreme Court can't delegate it because the obligation was constitutionally codified and assigned to them. So they can't use discretion to dismiss it, and they can't use delegation authority to delegate it to a different court, because that would be contrary to the obligation statutorily conferred and codified in the Constitution that assigns it to them, to the Supreme Court of the United States. So, at the end of the day, guys, I mean, everything is in our favor right now. Everything's in our favor. And that's why I say that, that the risk level is much lower. You guys can listen to what I'm saying. You guys can go out. You can read the statutes. You can read the laws. You can see that the things that I'm saying is true. You don't have to like me. You don't have to agree with me, but you can listen to the words I'm saying. You can say, you know what, he's right. He's right. It's right there. I can read it myself and I can see, which means that, you know, what is more risk? Is it going to an attorney and saying, please do a post-conviction relief, pay them $20,000 to rely upon judge-made rulings that is going to, you know, get you out of prison, relying upon something that is not even law to get you out of prison? Or is it saying, you know what, I'm not going to spend $20,000. I'm going to get behind this guy because the only thing that's keeping me from being heard in that court is the numbers, you guys. Numbers. You guys need to come behind this, get underneath this, because we have potentially tens of millions of petitioners in the same procedural situation. Because the question is, does the state have the authority to oversee a case in which the state itself is a party in the cause? The answer is no. Article 3 says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. So if a state is a party in a cause, then the United States Supreme Court has jurisdiction. That means that the state cannot be judging a cause in which it itself is a party to the case. And, you know, so, I mean, let's just talk about that for a moment. Like, how do we know that the state is a party to the cause? Well, first off, because they say so. State of Washington versus Tom. Okay, state's a party in cause. Well, how do we know even further? Well, we can go to the duties and responsibilities of a prosecuting attorney. And if you go to the duties and responsibility of a prosecuting attorney, you go down to item 4. Item 4, this is written by the Bar Association. So this is the duties and responsibility of a prosecuting attorney. Item 4, it says, the prosecuting attorney shall prosecute all cases, criminal and civil, in which the state has become a party. That's word for word what it says directly out of the procedure manual for prosecuting attorneys. The prosecuting attorney shall prosecute all cases, criminal and civil, in which the state has become a party. So if the state's become a party, if there's a prosecuting attorney on the case, that means that the state has become a party by their own word, right? By their own manual. And that's the very words that we need for the constitutional connection, because the Constitution says in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction, and their own words is that the state has become a party if there's a prosecuting attorney on the case. Now, the other thing is you know, these judges, what they've responded with so far is they've said, oh, the judges don't work for the state, the judges work for the county. And my rebuttal to that was, well, that's not fucking true, because tell me, Judge, where do you get your immunity from? Because you don't get your immunity from the county. So if you get your immunity from the state, then guess what? You're an agent of state. So don't give me that bullshit, right? You don't work for the county, you work for the state. So they do work for the state. They don't work for the county. Right behind them is the state's logo. And at the end of the day, when you go into Title 28455, which is automatic recusal for judicial officers, and you go down to item 4, it says that a judicial officer has a mandatory, self-executing, non-waivable duty to recuse himself if he is an officer of either party. And these are judicial officers of the state. Therefore, they have an automatic requirement to recuse themselves because they have a conflict of interest. They work for the plaintiff. Okay? So the automatic recusal it's not you that has to initiate it. You don't have to ask him to recuse himself. He has an automatic, self-executing, non-waivable obligation to recuse himself. And when you look at a failure to recuse under automatic recusal, you know, if a judge acts when they don't have jurisdiction, when they have an automatic recusal, according to Hill versus Weeks, United States Supreme Court, anytime the judge acts without jurisdiction, he is warring against the Constitution and committing the crime of treason. So these are very, very, very serious offenses that they're getting themselves into right here. So, you know, they have an automatic recusal. The judge does, right? And we can go even further. I mean, we can go into the very words of the founders of our Constitution, United States, because the father of our Constitution is James Madison. He wrote the Constitution. He wrote Article 3. And he also wrote the Federalist Papers, Circular Number 10. Because the Federalist Papers, if we want to learn the original intent of the Constitution, you know, what the framers and founders, you know, were intending to do, we would typically go to the Federalist Papers to look at what they had to say about this particular issue. So when you go to the Federalist Number 10, New York Packet, November 23rd, 1787, it was the article was titled "The Union as a Safeguard Against Domestic Faction and Insurrection." And it was written by James Madison. And what James Madison said in that article was, no man is allowed to be judge in his own cause, because his interest would no doubt bias his judgment and not improbably corrupt his integrity. With equal, nay with greater reason, a body of men are unfit to be both judge and party at the same time. So he's pointing out the fact that there's a body of men that make up the state, and that includes judges and prosecutors and CPS and law enforcement, all these people that are the body of men that make up state. When that body of men brings an accusation through one of their agents, the prosecuting attorney, then that same body of men cannot be presumed to be neutral and biased to act as a judge in the case, and as a result, that judge must recuse himself. And that's why he wrote Article 3 saying, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. So if a state is a party in cause, it does not have jurisdiction to oversee that case, and that judge has a constitutional obligation to recuse himself. Failure to do so means he is warned against the Constitution, committing a crime of treason, and any time that a court acts without jurisdiction, according to Civil Rule 60b-4, what they produce is non-binding on the parties involved in dispute, because the court never had authority to even be able to oversee that case. So if a court acts without jurisdiction, what it produces is void. And that's why I say that you guys, you don't need to go and appeal anything anymore. Because if the court has acted without jurisdiction, what it produced was void. And a void judgment never has to be challenged because it's void. It's always void. There's no statutory limits. There's no statute of limitations on a void judgment because it was never valid, and it can never become valid. And not only that, but even the Supreme Court of the United States, just in January of this last year, I was in the case. They said that the difference between a jurisdictional rule and a claims processing rule, which a claims processing rule is an appeal, you're appealing a claim. So the difference between a jurisdictional rule and a claims processing rule is that a jurisdictional rule can never be waived and can never be forfeited because it comes as the first duty to the court, right? It's the jurisdiction that creates the court and the court's authority. Therefore, it's not the court that can grant jurisdiction because it's the case that grants jurisdiction. So when they tell you to go back and argue with the state and exhaust remedies with the state, the answer is no, fuck you. I don't have to do that because the court doesn't grant jurisdiction. The case does, because jurisdiction existed before the court. It's the jurisdiction that creates the court. Therefore, that which is created cannot be above the creator. It's a simple issue of creator. So when you look at risk, this is a much lower risk, you guys. It's a simple issue of creator. So when you look at risk, this is a much lower risk, you guys, because we're relying upon the actual law. We're relying upon what the law actually states, everything together. In fact, once again, we can go back to the other founding father, Alexander Hamilton, right? Another drafter of the Constitution, and he wrote the Federalist Number 78. And what he said in the Federalist Number 78 is he said, the federal judicial authority of the Union must extend to all cases between a state and the citizens thereof. So if there's a dispute between a state and the citizens within that state, then the federal judicial authority of the Union must extend. It's not the state that has jurisdiction, it's the federal judicial authority that must extend. That's coming from Alexander Hamilton, written in the Federalist Number 78. So we have the founding fathers with the original intent, right, that are telling us what their intent was with regard to drafting the Constitution, right, and the rationale, their original intent. We have the judicial code itself that's telling the judges that they must recuse themselves. We have the duties, responsibility, prosecuting attorney saying right there that if a prosecuting attorney is on the case, that the state has become a party. And then we have the actual Constitution for the United States of America that says right there, never been modified, never been amended, Article 3 stands. So if the court lacks jurisdiction to oversee the disposition of dispute because they can't be a neutral, unbiased, fair decision maker when the state itself is a party in the cause, then guess what, you guys? That means that all the cases that are deriving from these courts, because they are acting without jurisdiction, are all void. Civil Rule 60b-4. Civil Rule 60 deals with the nullification or voiding of judges. Civil Rule 60b-4 says that a judgment is either valid or void. It's valid in all instances except for when the court rendering a decision lacks either subject matter jurisdiction or personal jurisdiction. If it lacks either one of those two things, what it produces is void. And a void judgment is always and forever void. It can never become valid because a court can never obtain jurisdiction when it lacks jurisdiction. So if you guys give me an opportunity here to advocate on your behalf, if you guys give me an opportunity to get behind me here, let me have this argument on your behalf, you guys can give up these pursuits for a post-conviction relief. You don't need to appeal because I can void your judgment. If you guys get behind me and let me advocate on your behalf, if you guys get behind me, submit these affidavits to me so that I can bring them in as this final blow to the Supreme Court, we can get this done. We can get this done, and I can void those judgments. Because when we put all these people in the same procedural situation, when we say, does the state have authority to be able to oversee a case in which the state itself is a party in cause? The answer is no. If I can effectively litigate that and effectively argue that, and we're at the Supreme Court now, I just need the numbers behind me in support. And when the numbers get behind me, I will have this argument, I will have this debate, we will win successfully, and when we do, then through what's called vicarious relief, we will provide relief to all of you. That's why I'm providing service to all these Supreme Courts of the states, all these Attorney Generals of the states, is because when I went and I served the highest executive officer and the highest judicial officer in these states, those states have been notified, they've been served, and that means that when we win through vicarious relief for the individuals that I served on behalf of those states, such as Rob Emmerich here in the state of California, Rob was the petitioner on behalf of the state of California because we served the Attorney General of the state of California and the Supreme Court of the state of California on his behalf for these crimes that are committed. Then when we win this argument, this debate, through Mr. Emmerich, all the people within the state of California will have relief because this highest executive and the highest judicial officer have been notified of crimes that are being committed by their agents, and now we can provide that relief. So vicarious relief means that all petitioners in the same procedural situation will receive the same outcome. So once we win, all that will have to happen is you will then submit a motion to vacate judgment for lack of personal jurisdiction, pointing to the case Downing versus Washington as the precedent, and in doing so, you'll submit it to the court that originally created the judgment, and that court will have no choice but to vacate the judgment. And remember now, anytime a constitutional obligation overturns a judgment, that court, that state, that government agency can never, ever come after you again, because you do not reward government for constitutional violations by permitting them another opportunity to be able to come after you. That would be a double jeopardy issue. But if you were to appeal, right, and you were to win your appeal, what happens there? Oh, you give them another opportunity. So this is going to remove their ability to ever be able to come after you again by showing that they acted illegally and unconstitutionally. They breached their obligation. They acted without lawful authority because they relied upon bullshit created by judges. And when we do, they can never come after you again for whatever it was that you allegedly did, because this isn't an appeal. This is the restoration of original liberties that have been deprived without due process through the violation of a constitutional obligation by government. So the motion to vacate judgment, we will be producing that very, very soon, right? But we don't need it yet. Once I win, I promise you, I will produce the motion to vacate. It will be widely available. It will be free to everybody. You guys will be able to download it, self-populate, just like the affidavits forms right now. You know, there's 22 blocks that you guys are putting in the affidavits. Same thing. You know, what I do for free because the country needs help, because I have the ability to do it. I have the knowledge to do it. You guys can listen to me and you guys can believe me, right? I do this because it's the right thing to do. I do this because I love my country. I do this because you guys need help, and that's why I don't charge for the things that I do. That's why I only operate on donations. Is because there's so many people that cannot get the help that they need because they're poor, and they're being oppressed because they're poor. So you know, this is why I do this, you guys. It doesn't do me any good to go and serve 33 states. It doesn't do me any good to, you know, sit on a train and a bus. It doesn't do me any good to do these things, but it does do a lot of people that can't get that help otherwise good. So, you know, I want everybody to know that there's a way, a right way and a wrong way to do things. And the way that we're doing it today is wrong. We need to treat our people with respect, because just as I said this morning, until we understand and respect every single life within our nation, every single person, we can never overcome this system. The President of the United States cannot do his job without the garbage man taking out his trash. That doesn't make him better than the garbage man. It makes him equal too, because we're all part of a nation, all doing our part that's necessary to bring about the outcome. So when we take a good portion of our society and we say, oh, you guys are just nothing but garbage, and we're going to lock you up in a steel box, force you into involuntary servitude so that you can labor for the direct benefit of the state in an institution that we would call a sweatshop in China, but they call a prison here in America, that's not the right thing to do. Those people are not worthless. And so we need to respect every single life within our society. We need to bring back all these people that we labeled criminal, and we need to say, you know what? How have we failed you? How has the system failed you? And so that's what we got to do. But just like I said this morning, also that that a patriot is defined as one who loves and defends his country. That's the definition of a patriot: one who loves and defends his country. Now, if you love something, then destruction can never be an optional outcome for that's loved. So if you're a patriot, then patriotism is not a call to arms. It's not let's go out and let's start hanging people, right? Patriotism is a dialogue between your fellow man and the larger world as a whole about not only what's good about your country, but how it can be better, right? Because patriotism is rooted in humanity, right? It brings peace and harmony. Because you will never seek destruction of that which you love. Now, nationalism, on the other hand, is rooted in arrogance. It's rooted in ego, right? And it will create conflict and wars. And so we need to say that, a patriot is one that loves and defends his country. And I can proudly say that I'm as much a patriot as this country has ever produced. And I'm very proud to say that. But if you say that you love your country, but then in the same breath can't say that you love your fellow countrymen, the problem is that this country is simply an aggregate of the people. So the way that you treat your people is a direct reflection on how much you love your country. And I can honestly say that after having been around this country, meeting all these public officials, I would say that they should be very cautious about using that word, because they're not patriots. Because look at what they're doing to our people. And the way that you treat your people is a direct reflection on how you treat or how much you love this country. So, we need to make sure that they understand that destruction should not be an optional outcome for what we're dealing with here. It should never be an optional outcome. A patriot would never seek destruction of that which they love. So, that's why I'm doing this in the least destructive manner possible. That's why I'm so slow, and a lot of people are irritated that I'm not moving faster. But the thing is that we have to do this in the least destructive manner, and that means that we have to use our words, and that means that it's going to take time. It's going to cause them to have to self-reflect and to eventually come to terms with the fact that if you want to be a piece of shit that's leading our country, then you will no longer be leading our country, because piece of shits don't have a right to lead our country, because that's going to lead our country toward a piece of shit, and we don't want that, right? If our country is being led by criminals, then that means they're going to lead us toward crime, and that's going to produce an environment of criminality, which will then produce a society of criminals. So we need to say, you know what? I don't want criminals leading us anymore, because I don't want to be a criminal. And so, we have to understand that this issue of criminality, the way we're trying to deal with it from the bottom up, where we go out and we arrest the people and we hold them accountable for the crimes they commit, it's never going to work. Because if our country is being led by criminals, because remember, the definition of criminal is simply one that transgressed the law. If you transgress the law, you are a criminal. It doesn't matter if you're transgressing the Constitution or you're transgressing a state statute. If you transgress the law, you are a criminal. So if our country is being led by criminals because they're not following the Constitution for the United States of America, then that means that we're going to be led toward criminality. And that will produce environments of crime, which will produce an environment of society of criminals. And then we wonder why we have mass incarceration. We are simply following our leaders. So the way that you have to deal with criminality is from the top down. You don't do it from the bottom up. You got to go to the leadership first. You got to say to leadership, okay, you need to be acting lawfully out of love, faith, obedience, and law, and respect for the will of the people. And when you do that, when you ensure that our leaders are acting lawfully, then we will be led in a good direction, which will produce a good citizenry. All right. But if our leaders, if our judges and our justices, if our Supreme Court of the United States is acting unlawfully because they've never in the history of their institution ever followed the Constitution of the United States of America, because they are anti-Constitution, because they're in the business of enslaving, right? And if the Constitution got its way, they would all be out of a job, because the Constitution sets people free and they have a desire to imprison and enslave everyone. Then we're going to be led in the wrong direction. Those people are criminal. So we need them to decide if you're going to continue to act unlawfully, because that's what I'm doing. I'm drawing a line in the sand and I'm showing them this is what the Constitution says. Therefore, this is what the law is. Here's what your obligations are. You guys are clearly operating outside of that, clearly operating outside of that. And as a result, what you're producing is unlawful. Because where there is no lawfulness, where it's unlawful, right, what you produce must be unlawful. So if you want to have a conviction be lawful, then you must act within the limitations of the law. You must act consistent with the law. Because if you don't act consistent with the limitations of the law or the parameters of the law, then what you're producing is unlawful. So today, they're acting outside of the law. They're acting unlawfully. They're acting outside of it. And I'm showing them, look, this is what it says, and you guys are clearly outside of it, which means that any unlawful act at the beginning cannot become lawful over time or by subsequent legislation. So as long as they continue to act unlawfully, because they're not following the law, then what they're producing is unlawful. Nothing that they do can be lawful because everything that they do is deriving from an unlawful act, contrary to the Constitution for the United States of America. So risk level. This is much lower risk, you guys. I need these people. I need all you to get behind this. I need all of you to submit an affidavit. I need you all to let me be your advocate. Let me litigate this on your behalf. Let me secure your liberties. And this is a big deal. I get it. And I know that faith is a very, very difficult thing for people to have. I have an inordinate amount of faith. I believe in this because God's shown me something that no one else had, and I believe in it. I would not be out here doing things I'm doing if I didn't believe that this was going to win. If I hadn't already weighed the risk and accepted the fact that I'm gonna be able to do this, I wouldn't be out here doing it. I would be out living a normal life, making money, but I believe in it. I know I can do this. I know that this is going to happen, right? I know that we have the power. And so now, if we can successfully argue this, then we can successfully reverse millions and millions of judgments, debt that's owed to society. We can reverse the direction we're going today and get these brothers and sisters back home to their families so that they can get the love and support they need to heal from the traumatic experiences that have been inflicted upon them by an institution that's been acting unlawfully since its inception. Right? We can get America out of the slavery institution once and for all. We can destroy this evil finally. We've been fighting this for 243 years. 243 years we've been fighting slavery. And we haven't been able to overcome it because we never understood this enemy. We've never understood this enemy because we have been told by our government that slavery is race-based, that it's black versus white. And they've been effective in continuing to proliferate that. But you guys, that's a diversionary tactic that they've created to keep us pitted against each other so we don't come together and realize that it's the government that's the real antagonist. They're the problem because slavery is not a race issue, it's an economic issue. We can't live in a society any longer where we have racial discontent or economic discontent because here in our nation, there's no place for that. There's no reason whatsoever why one human being would hate another human being based upon any classifications at all. Be it a woman, be it a gay, it doesn't matter. No classification should create any structure difference of our society. Every single person is an equal level. All laws apply equally to every person. We cannot continue to permit this institution, this government, to proliferate this idea that race is the basis of our hatred. We can't. We didn't do this. We didn't cause this. This wasn't our fault. They did this, and they managed to keep us in a state of ignorance, thinking that this is the cause of it. When in all reality, slavery is an economic issue, right? Because only the poor go to prison. Only the poor have to sell themselves into slavery in order to settle the debt that's owed to society, right? That's an economic issue. That's not a race issue. And so we haven't been able to overcome this issue, this system, because we've never understood this enemy. So if we can finally come together and say, you know what? We need to settle these disputes. If we need to stop letting the pain of the past control the happiness of the present, we need to figure out how to move forward. The way we move forward is every single person come together and recognize and appreciate and value the life of every single person within our society. Value what they do, right? Thank that garbage man for the garbage that he takes out for you because he's serving an essential role within our society, right? I mean, thank that teacher for the things they do because they're serving an essential role within our society. doesn't make anyone any better than anyone else. And that's the way we're supposed to be from the very beginning. But our founders and forefathers, they failed us. They failed us, and they've been leading our country to dissolution from the very beginning because our founders and forefathers refused to give up what they called their property when they created a nation where all men were going to be equal. So they didn't create a just system because it's not built upon just principles of all men being equal. They created a criminal enslavement system because they failed to give up their property, their slaves, and in doing so, they created a system that has the ability to perpetually discriminate. And that was not what the people agreed upon. That's not what the people envisioned. That's not what the people planned. And that's not what the people want. And so when we bring this to the attention of the people, that's what we're trying to do here with these affidavits, is create an event that's so big, so significant, that they will not be able to keep it quiet anymore. If I can get 500,000 criminal affidavits, if I can get more, I mean, I would welcome 2.5 million of them. But 500,000 criminal affidavits, if we look at just the poor, I mean, I would welcome 2.5 million of them. But 500,000 criminal affidavits, if we look at just the paper, alone, with 500,000, 500,000 criminal affidavits, that is 100 boxes of paper. 100 of those big boxes of paper, 10 reams in each box. That's 100 boxes of paper for 500,000. And these aren't going to be packaged tight because, they're going to be sent in. So we may have 140 boxes of paper for just 500,000 criminal affidavits. Imagine what it's going to look like when we're walking in with 140 people, each with their own box of criminal affidavits, of evidence from people and victims all across the country being committed by government, right? What kind of statement is that going to be, right? And that's 500,000. Think about if we had 2 million. That's going to be 400 boxes of paper. I'm going to have 400 people there with me to carry them in. Do you think that they're going to be able to make that go away? Do you think they're going to make that be quiet? No. These crimes are being committed in every single state, every single county, across the entire nation. And it's time for the people of the United States to understand that they can be arrested. Anyone can be arrested for any arbitrary or capricious act and then thrown into jail, deprived of their liberty, deprived of their right to be able to earn for their family and provide for their family, to use their property, all because the state says, I don't like you, and I'm gonna threaten and intimidate you and force you into pleading guilty for whatever crime I want with whatever punishment I demand. Because they do it every single day. Every single day. But unfortunately for them, that's a felony. It's a felony that, as prescribed by law, is punishable by death. So, they may be able to threaten us with a year worth of prison, but unfortunately for them, we get to threaten them with a noose and gallows, because that's what the law says happens to you if you don't do it, right? They have a far worse punishment than we do, and so we want to create this event. We want to have this be so big that when we get back to D.C., that they're not going to be able to shut it up, that we will have every single news station in the country there to meet us, greet us, and watch us as we walk in the Supreme Court of the United States to deliver oral arguments on behalf of people in the United States for the deprivation of rights and freedoms that have been deprived of them by this government. And that's the vision that I have. That's what God has shown me that we're going to be able to do. And we're going to do it for all of you. I'm going to have this argument. I'm going to successfully argue this on your behalf. And we will secure the rights and freedoms that have been deprived of you and your family for 243 years. And I'm a man of my word. I will do the things that I say that I will do. And I give you my word on that. So, again, we're heading down to Southern California right now. I don't have the money for a hotel tonight, so I would love it if we can make that work. But just as I said before, nothing changes my faith, you guys. If I have to go sleep on a park bench, that's what I'll do. I mean, it's not going to change my faith because I know the outcome. I already know what's going to happen here, you guys. We're going to win. We're going to successfully finish this in the next couple months, and we're going to prevent another 4 years. Doesn't matter who it is. I'm not saying this politically. We're going to prevent another 4 years of arbitrary, capricious, unconstitutional, illegal injustice against the people of the United States. That's what we're working on. That's why I'm doing this so fast. That's why I got to get across this country and I got to get this evidence because we cannot permit this to go on any longer. We cannot permit them to rob from our families, rob our children, lock us up for no reason so that they can force us into involuntary servitude and then label us the criminals when they themselves are the criminals, because they themselves are committing crimes that are punishable as prescribed by law by death. So we can't have criminals continue to lead our country. So if these people that have been elected, that I've spoken to and that I've sat in their office in Washington D.C. and informed them that this is what's happening, and if they want to return to established rule of law, and if they want to work with me to fix this problem, and to do it consistent with the law, because we will not compromise on the law. We will not do it. There will not be any compromise on the law. Duralex, sed lex. It may be hard, but it's the law. We won't compromise. But if you want to return to the established rule of law and you want to work with me to fix these problems, then you're welcome to come back. Judge, prosecutor, justice, Gorsuch, whoever. You can come and you can work with me and we can fix these problems. But if you don't, then we're coming after you. We're coming after you because you guys are fucking criminals. And we're not going to let criminals lead this fucking country anymore. That's the promise that I make to you guys. I give you my word. We will not do it. So we have Cash App, we have Chime, we have Venmo, we have PayPal. Everything I do because this is my passion, this is my purpose, because I love all of you, because I want to see our country be successful. But I do this for free. I don't charge for the things that I do, and I do this by donation only. So we have Cash App, we have Chime, we have Venmo, we have PayPal. They're all exact same as We Shall Be Free. That's WESHALLBEFREE. We're heading down to Southern California tonight. We do need to get a hotel room for tonight. We're going to be out tomorrow after a couple meetings down there. Tomorrow we're going to be out heading east. We need to serve the state of New Mexico. So that's on the agenda for our way through. Serve on behalf of the people in the state of New Mexico for the crimes that are being committed against them. So we're going to serve the Attorney General and the state Supreme Court there, just like we've served all the other ones. We're going to bring in the 34th state and incorporate the state of New Mexico. And we're going to probably spend a couple days there because I need to get some organization done. We need to figure out how we're going to overcome the suppression of the algorithms. And so we're going to come up with a plan, try to figure out how we're going to do it, because they're throttling my stuff really bad, you guys. You know that. The videos that I put out, these videos, I should be getting 100,000 views, and I'm getting 100 views, right? And we know that it's wrong. So we need to figure out what the problem is, how we can overcome it, how we can leverage some other support from you guys out there that may have bigger followers. What the problem is, how we can overcome it, how we can leverage some other support from you guys out there that may have bigger followers. So some of the options is that you guys have your own followers, and so if you want to do a live and you want to invite me on the live, that doesn't affect the algorithm, because that's me. So I would be more than happy to come out. We'll have a conversation on the live. That doesn't affect the algorithm, because that's me. So I would be more than happy to come out. We'll have a conversation on a live. You can ask me questions that are pertinent to you and to your followers, and I'd be happy to do that. I mean, my time, I have all the time in the world, and that would bypass the algorithm limitations that they have on me personally. So if you guys want, I'd be happy. Set it up. I'll come on. We'll do a live. We'll have a conversation. I'll give the information that your followers need, and that can help move this a lot faster, right? Another option is that all my videos, you can download them, right? So you go down here to the bottom. There's a little arrow that sits down here, right? And you type on this arrow here when you're watching my video, and then there'll be a list of options that come up across the bottom. One of those options is save video, save. And you can save that video, and then you can upload it to your own TikTok or Facebook or Instagram, whatever. You can upload it as if it's your own video. Now, I don't care if I get any credit for any of this, because I want the people to win, not me. It has nothing to do with me. I want the people to win. So you can take my video, you can bypass the algorithm, because the algorithm isn't on the video, it's on me, the person. So if my videos are being suppressed by the algorithm, it wouldn't be the same with you. So you can download my videos, you can post them onto your own platform, and we can bypass the algorithms doing that. But when you just take and you share my video, when you repost my video, it doesn't work the same way because it's me that's being suppressed. So therefore, when they repost it, it's going to continue to suppress it. So I'm not getting the views that I need. I'm not getting the following that I need. But once again, it's not about me. It's about the information. This information needs to get out there. The people of the United States needs this. There's 70 million people that needs the information that I have, these videos that I have, and that's not about me. That's about them. They need that information. So please, one option is go save my videos, repost them onto your own page as if they were yours, and in doing so, we can bypass some of the algorithms. Okay. So again, I operate on donation. Please, if you guys can, please donate. Every single cent counts, and especially right now. But yeah. So another thing that we're looking at is town halls. So you guys have saturation. You guys are within state of Indiana or you're down in San Diego or whatever. You guys have contacts within the area that I don't have. Right? I'm from DC. Right? I know people in DC, sort of. Right? But if I were to set up a town hall meeting and say this city of San Diego, it wouldn't be effective because I don't know people there. I don't have the connections there, but you guys do. So one option also over the next few weeks is if you guys want me to come to your area, if you guys want to host an event, right? And we're not talking, anything elaborate, but go to a church and reserve a big conference room and put out a flyer and whatever and say, hey, he's coming in town. He's going to answer your questions. He's going to be here for 3 or 4 hours. I would be happy to come to whatever area. Doesn't cost you anything. My time is free. The only burden I have is the travel expenses. And I'm traveling by train. So, that's another option that we would be able to get a lot of stuff out there. Right now, what we're doing is we're trying to build the affidavits. We're trying to so that information's got to get out. We have 4 weeks to get all the affidavits together. So, over the course of the next 4 weeks, before I go out and actually pick up the affidavits to return to DC with, this is a good time. We're really not going to have huge numbers, right, necessarily with these town hall meetings, but nonetheless, the more we can spend getting this knowledge out there, the more it can spread, the more it can be given and be beneficial to all of you. So if you guys want, just let me know. Make a time. If you guys want a Zoom meeting, we can do that as well. There's all kinds of different platforms, different mediums that would work, that would be beneficial. And the whole point is that there's a lot of people that need to hear the things that I'm saying. And I want them to be able to hear it. So you guys have got access to those people, not me. If you want me to get into your platform, you want to do a live with me, let's do that. Yeah, Telegram as well. I mean, you guys all know the mediums. Just reach out to me. Let me know. My time is free. So all that I care about is getting this knowledge out to the people, and whatever you guys want to talk about, because you never know what the people need to hear. Some want to hear about a plea bargain. Some want to hear about CPS. Some want to hear about IRS. Some want to hear about right of travel. We can talk about any one of those. Any one of them, right? Any one of them. So my degree is in substantive law. I'm the exact opposite of an attorney. Attorney goes through adjective law. They learn about ordinances, statutes, customs, and judge-made rulings. They learn about all the laws that remove freedom, because that's what they're in the business of, removing freedom. I went through substantive law. So my degree is in Constitution, it's in law enforcement, and it has to do with all the laws that restore freedom. That's what I do. I'm in the business of restoring freedom. They're in the business of removing freedom. So you can listen to what I'm saying, you can believe what I'm saying, because everything I'm saying is based upon the will of the people and the laws that the people established. I don't rely upon any bullshit that a judge said, because judges don't create law. So I rely upon everything that you guys have. That's why the things I say is consistent with your faith, consistent with your beliefs, because this is simply nothing more than the beliefs of the American people. This is our faith. So that's also the reason why I say quite frequently that I will work for everyone, but I will not work for anyone, because it doesn't do me any good, or it doesn't do the whole country or the people any good if I were to go to, say, the state of Louisiana and go into a courtroom and fight one individual case. Because if I can group everybody together into a common procedural situation and fight for the collective, then guess what? Then by winning one argument, all people will win the argument. So the individual cases would actually be a distraction more than anything else, and it wouldn't do the collective any good. That's why I stick with the collective, right? That's why I'm focused on the top, because if I can win on behalf of the people at the top, we can provide relief down, and that's why I don't come out and deal with individual cases, right? That's why I don't go out and do that. That's why when you guys ask me if I'll come and help with your case, that's not going to do us any good. There's millions of cases that need to be won, and the way that I can win them is by winning the top, winning the one case, and then we will provide relief down from the top to all of you so that you can be empowered with what you need to win your cases, okay? So, I'm gonna have to get off the train here. I think we're almost to Bakersfield. I got to transfer into a bus and continue the rest of the way. But thank you guys so much for joining me tonight. Hopefully this wasn't glitchy. Hopefully it was a little bit better than we've had. It kind of sounds like it, looks like it. Nobody's mentioned that it's been glitchy. So thank you guys so much for being a part of this. Thank you guys so much for being with me on this journey. This has been an incredible journey, and we're at the tail end right now, you guys. We are at the tail end. We are about to overcome this system, and so together we shall be free. Please continue to donate. We need that funding. And I hope to see you guys out on the road very, very, very soon. Thank you guys so much. You have restored my faith in humanity by letting me serve all of you. God bless. Thank you.